us on the couch and you have to self-analyse us. So,
Excuse me.
if I sit down, it's easier. All right, well. A win-win situation as well. So I'll sit down and take the weight of myself. So right. So first of all, what everyone should remember is when you're giving expert evidence, you're giving your overriding duty under the civil procedure rules is to the court, and it's the duty of an expert to help them accord matters within their expertise. So you need to really stick within your disciplines, not go off at tangents. The overriding obligation is to the court, not by the paying party. CPR 35.10 really sets out what's to be in a report, and really does the statement at the end of the report, and it's in a standard format. But I've set it out here, and just to go through it. So it would be a statement that he understands his duty to the court. Again, it's really emphasised both in the CPR and also in the statement that you make, and that you comply with that duty. You must state the substance of all material instructions, so what are you relying on in making your decisions? Whether it's oral, whether it's written, and you've got to really list it out. So it's basically so the court know, and it's clear why you're making the decisions and the assessments that you do. Right. The instructions themselves are not privileged against disclosure, and you are subject to question in the court by the defendant. Give direction. When we go now, there is the Jackson reforms. Costs and proportionality are the buzzwords that we're now facing. It's going to be a lot more difficult. Will we see joint experts? Well, the courts can order where there are two or more parties that on a particular issue that we have a joint report, and it may well be that in certain cases where it's not a major issue, then we will find that expert reports are on a joint basis. Often the peripheral issues, be it ophthalmic or whatever, in the more serious, say, head injury cases or orthopedics, are already taken on a joint basis, and that's what's done. It may well be that you find that the courts are pushing in this particular avenue. The court, as I said, has the power to direct the evidence is given by a single joint expert, and if the parties can't agree, then basically the court will has the power to basically decide. The new rule to CPR 35 also provides that costs, so you might find that your instructing solicitors are asking you for details of costs. There's cost budgeting, but the new CPR 35 provides that when we are applying the solicitors for leave to adduce expert evidence, we have to set out what the costs are going to be for each particular discipline, what they're going to comment on. So it is going to be a relevant factor, and I've already touched upon joint instructions. I think you might find that this is another factor, particularly when combined with the issue of proportionality that the courts are introducing. So your costs may be even more of interest to the court than they are to your instructing parties, because that may well limit the amount of evidence or type of evidence that's adduced. Discussions. Now, the court may at any stage direct a discussion between experts to identify issues, reach an agreed opinion. Most of you know about joint statements or will be familiar with this process. The aim is to narrow the issues or seek areas of agreement and disagreement. So obviously once you've met, sometimes an agenda's prepared, sometimes by the solicitors, sometimes by the clinicians themselves, and then they go through and set out the issues where there is agreement and disagreement. The court also may specify the issues which an expert may discuss, and really again for a joint statement. where there is an issue or there is uncertainty, I think it's often forgot that the expert can also ask the court for clarification or direction. So it's rarely done. I haven't come across it, but the power is there for you as an expert with the duty to the court to ask the court for clarification on specific issues where it arises. This is another development that's come in under the Jackson rules, which is called hot tubbing. Now, it doesn't mean that you get to all jump in the hot tub together, but it means that evidence given on a concurrent basis, rather than you going one after the other. Then basically you are both put there. The court may direct the parties agree an agenda. They take for concurrent evidence based on areas of disagreement identified in the joint statements. You both take the oath together and affirm, and then basically in relation to each of the issues on the agenda, the judge really has the discretion to take you through them. So this is very new, and we've adopted it from foreign shores. I hear that some judges are very keen on this, some judges are not. I haven't seen it in action, but it's one of the major changes that has come through with the new rules. After the process has been completed and the judge has gone through things, the parties' representatives may then ask questions. So rather than being effectively introduced and then the defendant or the claimant examining and then the other party examining, it's basically the judge leading and then the parties being left to ask questions. So it's a very different way of adducing evidence from what we're used to in the past. So after the process has been concluded, the judge may summarise the experts' different positions on the issues and ask them to confirm or correct the summary. So he basically goes and does a summing up, really, and then asks them to confirm or otherwise.
Can I check something? Is it all going to happen in a courtroom, or does the judge do it outside?
It will be in the court. So whilst it's there, most people will not get to court where you've prepared reports. I dare say that out of every 100 reports, you might get 5 or 6 that go to court. If that, it might be lower. Where it does go, it tends to be liability. On the quantum side, where the areas that tend to go relate to really whether the person is a protected party or not, and that tends to be the big disagreement. But a lot of cases are settled at joint settlement meetings or arbitrations, so even then it doesn't reach that stage. So it's one of those things that's there, and that's how the rules are pushing it forward to reduce the time. So rather than have 2 experts, one after the other, they're both there together to reduce the time spent. So that's the main focus and reason for it.
So can I clarify? You're not talking about these rare cases, 5 out of or less than 5 out of 100, those who are going to court and judge cross-examining?
Yeah, that's the ones I'm talking about. As in, the cases that get to court will now.
Those who are going to the court.
Yeah, those that go to court.
No,
No, the vast majority will, you'll prepare your report, don't worry about it, you know what I mean? The vast majority of cases will settle before then, but those cases that now go to court, you've got to be ready yourself from a different approach from that which was there before, in that rather than you give your evidence and then be cross-examined, then the defendant give their evidence or vice versa. The situation that's now going to arise is that you're both going to give evidence together, and effectively an agenda will be prepared and the judge will take you through the evidence, and then the various parties will then ask questions. So it's a different way of delivering the evidence than there was previously the case, and it's something, particularly if you are experts in this field, that you've got to be aware of the change in approach. I'm not saying it's very much up to the judge how he wants to do it. Some judges, they're the masters of their own court. Some judges much prefer the old style where they hear one party and then they hear the other party. But the rules now allow for hot tubbing,
So you've got to be aware of a difference in emphasis. Obviously, one of the things that I wanted to bring about is experts' liability. You prepare these reports, but obviously in 2011 things changed. It used to be the case that experts were basically not liable for negligence, really, in terms of the evidence that they gave. But the Supreme Court overturned the established position that they had protection from liability and negligence in 2011. And if you're not familiar, it's a case that I would really encourage you to look at and just examine. Not to scare yourself, but to look at the facts behind it, because I still think that it would only arise in very rare cases. So it's not here for me to intimidate, but just to really draw the facts to your attention. So the appellant had been involved in a road traffic accident and had brought a claim for damages for personal injury and loss. His solicitors instructed the respondent, a clinical psychologist. Is there any in the room? A lot of hands shot up then. As an expert witness, she advised that he was suffering from post-traumatic stress disorder. The other driver's insurers obtained an expert report stating the appellant was exaggerating his symptoms. The experts were ordered to produce a joint statement. They spoke by telephone. The insurer's expert produced a draft joint statement which was detrimental to the claim. The draft report stated the appellant had not suffered PTSD as a result of the accident. The respondent said that she had not seen the insurer's expert report and later asserted that the joint statement did not reflect her views. She'd signed the joint statement, may I add. The background, basically the claimant in this case was unable to obtain permission to get further evidence and was basically forced to settle on terms because of what their own expert had said in the joint statement. He brought a claim against the clinician for damages, for the lost opportunity of recovering higher damage as a result of her negligence. And the previous decision was basically Stanton and Callahan that the action was struck out at first instance, but it then went to the Supreme Court, and the Supreme Court was asked to determine whether an expert witness could rely upon immunity in relation to the preparation of a joint witness statement. However, the judgment covers broader issues of whether an expert enjoys immunity from liability when acting as an expert witness. So it's a very important decision. It's a 2011 case. It's available online. So in the lead judgment, the President of the Supreme Court, Lord Phillips, rejected the argument that the overriding duty that an expert owed to the court, that the overriding duty that owed to the court to give a full and frank evidence would conflict with a separate duty of care owed to the client. So there's only one duty, the duty to the court. An expert initially provides advice for the benefit of a client. If further evidence emerges or the expert is later persuaded that his initial view was wrong, then there is a duty to both the court and the client to make the concession. An expert may be reluctant to change his mind, but that is not due to the risk of being sued. If he fails to give full and frank evidence, the expert already faces a risk of wasted costs order in disciplinary proceedings. So it went on. Lord Phillips asked why there should be any indemnity where he's got to fulfil his duty of care. And the onus is upon the expert to justify the cloak of immunity, so that protection that was afforded. So he noted that the House of Lords had swept away advocates' immunity. That was for counsel, and that had not resulted in any reduction in the availability of advocates being able to act or an increase in any claims. So professional indemnity insurance was available to cover expert witnesses, and professionals owed duties of care in their everyday activities which run the risk of negligence. So the question was asked was, why are experts in a different position? I must say that the previous state of affairs and the protection afforded to expert witnesses had been there for over 200 years, nearly, so it was a big change, however. So it went on by saying that by removing the immunity, disappointed litigants will now be able to pursue claims against expert witnesses. However, as Lord Phillips pointed out, they will normally require expert evidence and this will protect them from vexatious claims which would not have the supportive evidence that would be susceptible to strike out. In the case before the court, however, she hadn't read the defendant's evidence. She'd signed the joint statement that basically conceded that she agreed with the defendant's evidence, and that's where she fell. Immunity in legal proceedings was abolished. Lord Dyson said that the prospect of a client pursuing a negligent claim is unlikely to tempt an expert to disregard his overriding duty to the court. He stated that the mere fact that immunity is long established is not a sufficient reason for blessing it with eternal life. So, unfortunately, 200 years it was long enough. So it was not in the public interest to justify denying a remedy to a person who suffers loss as a result of the breach of an expert's witness's duty. So there were two dissenting judgments because there was a worry that opening the floodgates, or so to speak, would mean that there would be less availability of experts coming to it because they would be concerned about the prospects of being sued in the litigation. And also the conflict in the duties. And they looked at witness immunity, family, public law and other proceedings, but they decided that reform, if there is going to be a matter for reform, is a matter for public policy, so Parliament, rather than the courts. So immunity was abolished. Now, the decision itself, I don't think it's opened any floodgates. It would be if you express your opinion based on the facts, then it's going to be very, very hard for a disappointed litigant or defendant to be able to proceed against you. It's only where you haven't fulfilled your duties or you have been what I would say is grossly negligent, such as in this case where you effectively have failed to read your opponent's evidence and then basically acquiesce to what their reasoning was in the joint statement. So for those reasons, I don't think there will be much detail. So the main things to consider are your duties are always to the court. You've got to be aware of setting out all the material instructions. If you need guidance, you can ask your instructing solicitor, but ultimately if you're still unhappy, you have the option to go to the court. There are lots of changes coming in. The court are restricting availability of evidence. Whether we will have 2 experts in every case, as used to be the policy, remains to be seen. So there will be a constriction in the availability of evidence, and your costs, as ever, will be very, very important. So, thank you.
Can I ask quickly one question? The expert's ability to, or the possibility of going to court directly for further inspection or clarification, they have to go via their instructing solicitor.
No, you can
Make an application.
They can make an application.
Make an application.
You can make an application, but given that experts are rather naive about how to go about it, can they go through their instructions?
I've actually had a case where an expert's done it, and he did the right thing, which is he made the application himself to court. Sorry, the question is where you have an expert in the middle of court proceedings who has a problem, yeah? How does he go about referring it back to the court? Does he go through his instructing solicitor? Yeah. The case that I had was where the expert actually had a problem with the solicitor, and what he quite properly did was he went to court and got it resolved by going to court. Yeah. You basically just make you issue an application notice, which you can seek advice from your solicitor or from the court. And then it goes to the judge, or else you write to the judge and the judge will probably request a hearing. Yeah?
But in this case, we need to take any consent from the patient.
No.
No, because you have the duty to the court, and if it can't be clarified and you are still unhappy,
effectively you are seeking direction of the court. Your instructing solicitor or the instructing party is not the person to whom you owe the duty.
What happens in some cases when the solicitor suppress the report?
Well, in those it won't arise because normally the other side will not know about it. Now, Mark will touch
So
upon a case.
I'm going to come to that, okay? Right, Richard has done civil proceedings, yeah? What I'm going to talk very quickly about are proceedings or issues within the Court of Protection jurisdiction to do with capacity, yeah? How many of you have done capacity assessments? Whoa, so you all know what you're talking about, yeah? And there's not much that I need to address you upon, is there? Yeah? So, what we're going to look at, MCA guiding principles. This is sections 1, 2 of the Act, which I'm sure if you've all done capacity assessments before, will basically be set in stone within your hearts and all the rest of it. Yeah? I'm not going to go through any of that because I assume that you all know it. Yeah? But the bottom line is, I practice within this jurisdiction every day. Yeah? I have to come back to what is on there every day because at the end of the day, that is the framework within which you, me, and the judges operate within the Court of Protection. Yeah? Basic principles, person is assumed to have capacity. If the assumption is in favour of the individual, therefore that assumption has to be reversed. Capacity is issue specific. I do plenty of cases where an individual may have litigation capacity. They may have capacity to make decisions about their property and finances, but they don't necessarily have capacity to make decisions about where they live or what their care package should be, or whether or not they can give consent to the restrictions that are being placed upon them. Yeah? But it's all about the issue. And when you look at the issue, for each issue, you go back to all of this. Yeah? And you have to go back to all of that in relation to every issue. And that has to inform the reports that you prepare. Yeah? Yeah, so, thanks, Richard. Again, that's just me making the same point. There has to be an abnormality of mind, and then you have to look at, you have to go through the basic tests. Yeah? Thank you. Yeah. 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 Going off tangent a bit, yeah? Who can assess capacity under the MCA? Sorry? Sorry?
Whoever is doing the intervention.
Yeah, so it can obviously be, certainly within a clinical setting, it could potentially be a nurse, yeah? It is not just the confine of a doctor or a psychologist or someone like that, yeah? Again, we come back to the issue-specific issue. And in addition to that, and certainly I'll come on to that, capacity assessments are not the domain of doctors or psychologists, nor should they be. Yeah? Anyone who thinks that they are is going against one of the guiding principles of the Mental Capacity Act. Yeah? So any report that you prepare as a clinician or as a medical legal expert in court of protection proceedings is only one factor that goes into the mix in terms of the ultimate decision. Yeah? I am going to keep labouring that point because to me that's very important. Yeah? You know, I'm a lawyer, you're doctors, etc. Certainly when it comes to practicing within the court of protection jurisdiction, the way I look at it is that we have to contribute to the decision that has to be made by the judge, both as lawyers and doctors, psychologists, because at the end of the day, the judge has to look at the views of different individuals to arrive at a decision. Yeah? Richard's spoken about the civil procedure rules. Yeah? The rules that apply in terms of the Court of Protection are obviously the Court of Protection rules. How many of you are familiar with those rules? How many of you have prepared capacity assessments for court purposes? Yes? And none of you are familiar with those rules? At the end of your report, you will or you should have signed off a declaration, which under these rules has to state that you are familiar with those rules. Yeah? Okay? The declaration is very similar to the declaration that Richard's obviously spoken about in relation to civil procedure proceedings. Yeah? And the key bit of the rules is part 15, which sets out the rules that apply to court reports and the use of experts. Yeah?
One problem is when you keep saying court report, outside the court of protection reports, vast majority of the compensation claims related report that I see, I'm often asked by the solicitors, inspecting solicitors, to comment about the capacity. And I keep saying now, from this rule came up, that capacity is situation specific and time specific, and if it's to do with whether he can manage his own money or inspect solicitor, I'm not the best person to answer.
Now you see, that's great, because what we're going to do here, we're going to create a line down here, yeah? And I'm going to come over here, and Richard will certainly be over there, yeah? Okay, right? We've just been having that discussion before you started, yeah? There's a case that I'm going to refer to at the end that Kieran was involved in, yeah? Where a High Court judge in civil proceedings had to look at capacity issues, yeah? What's interesting when you look at that case and the barristers involved are the cases that they use to guide them, yeah? They're the wrong cases, yeah? They are not court of protection cases. The leading case on capacity is Mr. Fearing. The Crown versus Cooper, which was when? 2009, which is a decision by who? House of Lords. Key judgment being given by? Right. Okay? That's the key decision. Right? That's a court of protection decision. Okay? 2009, the decision that they rely on here is Masterman and Lister, which is a pre-MCA case. It's bad law. Yeah? It's a waste of time. And you've got a High Court judge using that decision. Yeah? Everything that you've said, in my view, is quite correct. Yeah? The jurisdiction to determine capacity issues is not the Queen's Bench Division. Yeah? It is the Court of Protection. Yeah? And within the Court of Protection, those rules go. Yeah? However, to sort of come across here, what I would suggest is important is if you are asked to assess capacity within civil proceedings, you have to be quite clear as to what your instructions are, yeah? And when you set out your views on capacity, you make all the points that you've made, and you make it quite clear that you are following sections 1 to whatever of the Act, yeah? Yeah? So clearly you are going to be asked to look at capacity, but if you are going to look at capacity, as a medico-legal expert, that's actually quite difficult, because in order to do it properly, clearly you have to seek the views of the family, you have to look at all the stuff in relation to the past, etc. And you know, the bottom line is, you might not be getting paid enough money to do that, yeah? Okay? Because that takes a lot of time, yeah? The most recent case I've done, which is a very contentious case, where I had a psychologist, he had to go back to the home where the lady I was acting for, he had to spend 4 hours with her, and then he spent 15 hours looking at the records, yeah? Quite rightly, because the decisions that he was having to make were very, very, very important, yeah? I'm sure that doesn't help, but it sort of deals with the issues, so, yeah? You've got the slides, have a look at the rules, yeah? And certainly anyone who prepares reports should remind themselves of those, should look at the rules. You can get them from the internet. There isn't that much difference between the rules and the CPR, yeah? And again, the overriding duty is to the court, yeah? Sorry, Richard, yeah? Again, sorry, Similar provisions as Richard was talking about expert evidence. Yeah. Yeah. Sorry. Differences. Yeah. I don't know whether the people who've prepared reports, yeah, are the reports that you prepare different in style when you're looking at court of protection issues, different to the reports that you prepare for civil proceedings? Yes or no? Very quickly, no. I think they have to be slightly different because they need to set out in much greater detail the discussions that you've had with the individual. Yeah? And I think I've run out of time, so that's that.